but since there are so many folks here and people just cycled in, just want to make sure that sign-in sheet is getting circulated. Still happening. Okay, great. So I will take a seat, but we can start with some of the other intro stuff while that's still happening.
Excellent. Morning, everyone.
Morning.
Thank you for being here today, May 1st, 2025, and we are meeting to conduct the hearing on application 8B0344-9 filed by the applicant AWRE Vermont Resorts Inc. LLC, excuse me. The application is seeking partial finding under Criterion 9B, primary agricultural soils. This application is not seeking a permit to construct at this time. So I just want to make that clear for everyone. This is just a partial finding hearing. And this is not a application to construct. That will be a secondary process. The proposed project is generally described as the redevelopment of the Southern Vermont College campus into a resort consisting of a hotel, chalets, and various amenities. The project is located at 982 Mansion Drive in Bennington, Vermont. My name is John Casella II. I am serving as the acting chair of the District 8 Commission. I'm joined by my fellow commissioners, Don Miller on the end and Devin Fuller. In accordance with 1 VSA 312 Vermont's open meeting law, I confirm that we have taken the following steps. We are providing public access to the meeting by an online video conference with additional access through telephone. We're using the Microsoft Teams platform for this hybrid meeting. All members of the commission have the ability to communicate during this meeting, and the public has access to listen and, if desired, participate in the meeting by attending in person, downloading the Microsoft Teams application, or by calling in the toll-free number provided in the meeting notice. In addition, we have provided public notice of instructions for accessing the meeting. We previously gave notice to the public of the necessary information for accessing this meeting, including how to access the meeting using telephone or Microsoft Teams in our meeting notice. That document, including those instructions, has also been provided in the meeting notice on the Act 250 database online. Couple housekeeping items. This meeting is subject to Vermont's open meeting laws. By participating, you're consenting to being audio and visually recorded, and for that recording to be published in the board's online database or its YouTube channel. Please be aware that the microphone that is used to record the hearing is extremely sensitive. It will pick up on and record whispers and side conversations. Anything that is recorded will be published as part of the public record. So note that. In addition, any written information or exhibits provided to the commission or Act 250 staff regarding official state business are considered public record and will become part of the permanent record to be published in the board's online database. If you'd like to speak during the hearing, please raise your hand and wait to be recognized by the chair. Everyone will have a chance to present their evidence and respond to the information presented. There's no need to interrupt or talk over anyone. Everyone will have an opportunity to speak. We do have a few people online, so the chat function has been disabled from the Teams meeting. This hearing is being recorded, including any noises, barking dogs, personal conversations, etc., made when your microphone is not muted. Therefore, please mute your microphones when you're. If you're participating online via Teams and would like to speak during the hearing, please raise your hand using the raise hand feature, which is located the toolbar in the top center of your screen. For participating exclusively by telephone, press *6 to unmute and speak up so we can hear you. Finally, and this is important, please do not log into the Microsoft Teams meeting on your computer or other device and participate on your phone at the same time. That will cause some very distracting audio feedback that can greatly disrupt the hearing. The purpose of today's hearing is that we are charged with collecting evidence to inform partial finding under Criterion 9B. Let's start by taking a roll call attendance of all persons participating in the meeting. If there's anyone here in the room that has not yet signed in using the sign-in sheet, I'd ask that you do that now. Is everybody signed in?
And I will just note, I just did a quick look. It looks like everyone didn't provide an email address. That is fine. It's just we won't be able to follow up with you about information. So if you did sign in and didn't provide an email address or a mailing address, I would encourage you to do so if you want to be informed of future information. I'm sorry, I have to grab the pen. That was it. I think with the number of folks that have, we will skip the
I was
roll
hoping
call.
you'd say that.
Yeah.
Excellent.
Oh, sorry.
We'll do the online folks though.
Yeah.
Okay, excellent. So we can read the Teams meeting participant list to identify anybody that is participating in the hearing remotely.
Yeah, I can do that. We have Kelsey Schweitzer, Ari Rockland Miller. We have a telephone number here. What I'll do is I'll unmute each of you. I'll start with Kelsey and then the telephone number and allow you to introduce yourselves. So what I'm going to do is I'm going to unmute you, Kelsey. And then you can unmute yourself and you can introduce yourself. And I see you have your hand up, and you can ask the question of the chair at that point. Okay, Kelsey, you should be able to unmute yourself now and go ahead and introduce yourself. Kelsey, you should
Can you
be
hear me
able
now?
to. Yeah,
There we go. Great. Hi, Kelsey Schweitzer, co-counsel for Alfred Weissman Real Estate. And co-counsel Chris Roy is currently in the waiting room and unable to get into this meeting. Could somebody let him in, please?
I do not see him in the waiting room, so let him in.
Okay, I will let him know and we'll resolve that on our end. Thank you.
All right. Okay. And then we have a telephone number here. It's 802-442-5473. I'm going to allow you to, looks like you can unmute yourself now and introduce yourself, please. Again, person on the telephone at 442-5473. You can unmute yourself and introduce yourself at this point if you would like to.
*6.
Oh, *6 to unmute yourself. Okay, well, we have a person listening on the phone, but they have the ability to introduce themselves now, but they're not doing that. Okay.
I think that's fine, and we'll just say there was, in the public notice, there is an email address for the district office. So if you're attending remotely, you should email that email address with your contact information, again, if you want future information about the proceeding.
That probably corrects it. Why don't we let Chris introduce himself? Hi, Chris. I see you here now. We're gonna allow your mic so that you can turn your microphone on and introduce.
Good morning. I apologize for the mix-up this morning.
Okay, no problem. And, oh, I did let Ari introduce himself. Ari, you want to introduce yourself? Give me a second. Yes, definitely. Okay, Ari, go ahead. Turn on your mic and introduce yourself.
Hi, my name is Ari Rockland Miller. I'm with the Agency of Agriculture, Food and Markets in Vermont, and my title is Senior Agricultural Development Coordinator. Thank you.
And I
Thank you.
apologize, I didn't formally introduce myself. I'm Chris Roy with Downs Franklin Martin, and I'm counsel for the applicant, along with Kelsey Schweitzer, who's also monitoring.
All right, thank you both of you.
Okay, we'll get started. Participants are reminded that all people requesting party status and any other person who would like to continue to receive documents associated with the proceedings must provide us with an email address, as when stated earlier, or a mailing address. If you haven't already done so, please email the district office, describe your interest in the proceeding, and provide your full name and contact information. You can find an email address for the district office in the official notice of this hearing. The commissioners have reviewed all the materials submitted with this application, in part with an eye towards identifying any conflicts of interest that a commissioner might have. We are not aware of any conflicts of interest that need to be disclosed at this time. Outside of today's proceedings, I may remind everyone that all communication, whether by letter, email, telephone, or in person, must flow through the district coordinator, Quinn Mann, and not flow through other parties or commission members. So we'll do a brief overview of the hearing process. First, the application will present a brief project overview. Then the commission will consider requests from individuals or organizations, organized groups seeking party status or other participation rights, and determine under which criteria they may preliminarily be admitted. You may want to participate in these proceedings as a party. Party status is important for at least two reasons. First, a party may introduce evidence, bring in experts or other witnesses to testify, and take part in arguments. Second, you may be unhappy with our ultimate decision. Only a party may appeal our decision to the environmental court. Parties will have an opportunity to testify in order to introduce evidence they would like to enter into the record. When you speak, please state your name for the record. Does anyone have any questions at this point in the process before we move forward? Next one. I'm now going to ask everyone who thinks they might address the commission during this hearing to swear or affirm that they will tell the truth. Accordingly, anyone who expects to address us, please raise your right hand. Okay. I'd like to have anyone raising their hands, please introduce themselves and their affiliation for the record. Start in the front row.
Sure. Michael Cohen, Alfred Weissman Real Estate.
Thank you.
Developer applicant.
Yeah, Daniel Heil, civil engineer with VHB.
Dan Monks, assistant town manager for the town of Bennington.
Thank you, Dan.
Fred Booker, property adjoined.
Thank you. Go to the second row.
Alan Weissman, Alfred Weissman Real Estate Developer of the project.
Joseph Ginzano, Alfred Weissman Real Estate Developer of the project.
Leslie Addison, resident North Bennington.
Brad DeBoer, Bennington Area Trail System.
Brian Lent, SVMC, Hospital.
Thank you. In the back? Yep.
Kevin Bisacchio, resident in Bennington.
Thank you, Kevin.
Yeah.
Oh, sorry, did get it. Anyone else? Move to online. So I assume Chris and
Go ahead, they can hear you.
Okay, great. We'll start online. Anybody that would like, this will be a little bit difficult because we may see you in a different order than anyone else.
Yeah.
But I'll let you unmute and announce.
So I'll start with Chris. Go ahead, Chris. You can
Yep.
unmute yourself.
As I stated earlier, Chris Roy with Downs Racklin Martin, attorney for the applicant.
I will. And Ari, go ahead and unmute yourself.
Hi, AWRE Rockland Miller, Vermont Agency of Agriculture, Food and Markets.
And Kelsey, you're going to provide testimony. Go ahead and unmute yourself and let us know. Oh, probably Kelsey's not. She's working with Chris. All right, go ahead.
Okay, so I'll have everyone re-raise that plans to testify, re-raise your right hand. Do you solemnly swear or affirm that the testimony or evidence that you shall provide relative to the consideration of this application shall be truthful, accurate, and complete under the pains and penalties of perjury? If so, answer I do.
I do.
I do.
Excellent, thank you. The applicant will now give us a brief overview of the project. After that, we'll consider petitions for any individuals or organized groups seeking party status, other participation rights. I'll kick it over to the applicant to give a brief overview.
Start.
Sure. Yeah.
Stand or
Sure.
just?
whatever you want or absolutely.
Michael Cohen with Alfred Weissman Real Estate, the developer. We are seeking a partial finding on the agriculturally dedicated soils on the property, for the purpose of being able to finalize our full application for the site plan. Our intent is to build an upscale destination resort with a spa, restaurant, and hotel keys, and obviously resort amenities. The application, as you'll notice when Dan goes into it, covers a lot of acreage, partially not because we're building in those areas, but because we don't know until we finalize the plan where conduits like geothermal lines, electric lines, plumbing lines, sewer lines are going to need to go. And we didn't want to have to slow down the second stage of the application process when we file our final plans to have to constantly amend it. So we just decided to make the application for that full area rather than nuance the individual areas, and it'll make more sense when Dan presents it.
Yeah. Dan Heil, civil engineer with VHB. As Michael mentioned, we're seeking partial findings under Criterion 9B for the orchards today. Lifting a portion of the on-site mitigation areas and new impacts to proposed areas on site. The intent of seeking partial findings at this time is to ensure the proposed area that will be developed is feasible as we move into the design development stage and future local and state permitting. The project is located on a 371 acre tract of land at 982 Mansion Drive in Bennington. It's currently zoned institutional and professional, or IP zoning. Back in 2022, the town of Bennington rezoned the parcel from rural conservation and rural residential to institutional and professional. The rezoning was designed to optimize the potential use of the parcel by allowing resort use, which we will be proposing under a future amendment. The rezoning is referenced in Exhibit 5, the town letter of support, as well as Exhibit 6, Stowe Club Highlands, an appropriate circumstance memo from DRM and VHB. Before diving into the prime ag soils on site, I also wanted to point out a couple other things. While the parcel is not within a designated growth center, it does border the Bennington designated growth center directly to the east of the site along Monument Ave. And the parcel is also currently served by municipal water and sewer. Up until 2016, the property was served by an on-site water supply. The former college was served by an on-site water supply. And then the town of Bennington constructed a municipal line that does run through the site that the college hooked up to, and would be the intent of the resort to hook up to that municipal line as well, along with the existing sewer on site. Parcel is subject to previous Act 250 permitting under Land Use Permit Series 8B0344. We've worked with AWRE and the Agency of Ag on confirming the existing prime ag soils on site, the existing on-site mitigation areas, as well as the proposed impacts. These acreages are outlined in the February 19th letter from the Agency of Ag, which was provided as Exhibit 9 in our partial findings application. With that, I was going to pull up a couple plans on screen.
Yeah, I think for right now, it's meant to be a brief overview, just to
Okay.
give people context who might be requesting party status. So we will definitely get into the plans, but I
Okay.
think a lot of people are here because they're probably familiar with the property. And so I think
Sure.
that you gave a sufficient context of what
Okay,
we need right now.
sounds good. I'll hold off on
Yep.
the ag then. Thank you.
I'd now like to ask for any party status requests, and we'll provide further explanation of party status. Do we have anyone interested in party status at this point?
Is this only for party status for 9B?
Correct.
Okay.
Yep. Primary ag soil.
And are you talking about folks that don't have party status automatically?
Correct. Okay. Yeah.
So yeah, for process purposes, like the town of Bennington has automatic party status, some other
Regional
like the RPCs, that sort of thing.
Okay, so we can skip majority of this section.
You want to just ask,
Yeah.
sorry, you want to just ask, I can't read, so I have to move it over so I can read it. The person who's available, who's here online.
Yes, would anybody online like to request party status, raise your hand using the raise hand feature?
You are,
Automatic.
you're automatic.
Yeah. For the record, the commission visited the site earlier today, where we reviewed the site plan and walked around the property. We observed the areas under consideration in 9B, primary ag soils, general property. Any comments that were made at the site visit were not recorded and are not part of the record. So as we stated in the site visit, if there's anything that people would like to get on the record, you'll have to re-talk about those items. So the first area that we'd like to start with is the Stowe Club Highlands analysis. The applicant seeks to amend a critical permit condition, specifically condition 13 of permit 8B0344-5, which states pursuant to the commission's findings of fact and conclusion of law under Criterion 9B, the permittee shall protect 64 acres of primary agricultural soils through on-site mitigation. As depicted on Exhibit 37, in order to compensate for the acreage of primary agricultural soils whose agricultural potential has been reduced or eliminated as a result of the project and previous projects. Therefore, the commission must conduct the Rule 34E analysis. The applicant has provided an analysis that considers the Stowe Club Highlands analysis, which is Exhibit 006, which the commission has reviewed. To begin, I will ask the applicant to give a brief overview of their Stowe Club Highlands analysis presented in Exhibit 006.
Chris, do you mind jumping in?
Go ahead and try it. You, unmute
Thank
yourself. There
you.
you go.
Yeah, and I'll be brief, because I think this analysis was laid out in detail, with Exhibit 6, which was the memo that we and VHB had submitted on this issue. And Rule 34E has a special place in my heart because I happen to be on the environmental board when we were tasked back in 2007 to take the Stowe Club's Highland analysis that had appeared in decisions and reduce it to a rule. And to be quite honest, I think this is precisely the kind of case that folks had in mind when they developed the Stowe Club Highlands analysis in Rule 34E and the test relating to balancing the need for finality in permitting with the reality and desire to be flexible when appropriate. Without simply repeating everything that is laid out in the memo, this is not a case where the applicant is trying to relitigate a prior condition. Instead, it is premised upon some fundamental changes that have taken place with respect to the pertinent law, as well as the use of the property now and going forward. So there's no question but that we're asking for modification of a condition that was an important condition before, primarily based upon the Primag soil rules that applied back in the time, which did not provide for offsite mitigation. So as we've laid out, the first element under Rule 34E is whether there are changes in facts, law, and regulations that favor flexibility. Here, as we talked about, and as you know, as members of the community, Southern Vermont College ceased to use the property back in 2019. And this, as a consequence, the property has remained unused. And as we all know, if you have buildings that are not being used and maintained regularly over time, their condition will deteriorate. And so those are the changes of circumstances here, along with the economic reality that several small towns in Vermont have encountered over the last decade, which is that a lot of small rural college campuses are no longer economically viable, and it's crucial to find a way to reuse those properties in a responsible, thoughtful way, as opposed to, just tearing them down. And that's particularly pertinent here, where you're not only talking about a former campus, but also the extraordinary Everett Mansion, which, if you've had the opportunity to visit, is really quite a marvel. So those are the changes in facts. Changes in regulations, as the town has acknowledged in their submission, realizing that a college campus was unlikely to be the future use of this property. The town went through a thoughtful planning process as to what would be an appropriate use of that property under the circumstances, and they've rezoned it as institutional and professional. And of particular note, that rezoning expressly allows for hotel and resort uses as permitted uses. That was not the case before, when it was a college campus. And so the town and the community as a whole has put a great deal of thought into what is the most viable and reasonable use of this property going forward. They identified the hotel and resort use and then went through the process of rezoning for the property so that that type of development would be allowed. And lastly, regarding changes in laws, I mentioned briefly, when most of the conditions, well, most of the permanent amendments and all of the soil related conditions were imposed on this property, it preceded the time in 2006 when the General Assembly expressly allowed for off-site mitigation with respect to primary agricultural soils. So that is a tool in the toolbox now that wasn't available when these conditions were originally imposed, and frankly, would likely have been the more appropriate mitigation approach with respect to this property, given its use as a college campus back in the time, but that option wasn't available then. It is available now. So we think that first factor weighs heavily in favor of flexibility. The next element is changes in operations, which necessitate the need for an amendment. And again, that has to do with the viability of a college campus use going forward, given modern economic realities and what is now allowed on the property under zoning, which was not previously allowed. The next element is whether innovation and alternative design favors flexibility, as the application materials emphasize, and as you saw out on the site, while the design isn't finalized because they need to know whether and how the prime ag soil issue is going to work out, the fundamental plan here is to develop this property with a very soft touch and with one that is very mindful of maximizing the prime ag soils where possible. And in fact, there's soil that has been set aside, which is actually going to be converted into an active orchard use, which is wholly consistent with the goals of the Criterion. So we think again that element favors flexibility. The last, and another item is whether there are other important policy considerations favoring flexibility. And as we mentioned in our memo, there is a real jewel and asset on this property, the Everett Mansion. As anybody who has undertaken repairs at home can imagine, renovating that property appropriately, given its historic significance, is not a small undertaking and is not an inexpensive undertaking. And so in order to preserve that community asset, it's necessary to come up with a use of the property that is going to allow that rehabilitation and renovation to occur as part of a broader use that is consistent with the planning goals of the community, and so on. So we think that important policy consideration also favors flexibility. And the last one relates to manifest error. This isn't a question of the commission previously having made a mistake in imposing the conditions. Instead, we think it's more a matter of the commission only used the tools that were available to it at the time. So, and the last part is the application does not rely on simply writing a check to deal with all soil mitigation. There is a concerted effort to maximize as much as possible retention of the prime ag soil on the property. And it is it's only that portion of mitigation which can't be done on site that is part of their request to allow for off-site mitigation. So we think under Rule 34E and the Stowe Club Highlands analysis, this really, if you are thinking of an example of precisely when flexibility is warranted over finality with respect to being able to be nimble and thoughtful and responsible regarding the use of important property over time, we think the subject property fits that bill. And the applicant requests that the commission recognize that and allow for amendment of the prior conditions relating to primary ag soil. And if you have any questions, I'm happy to answer it.
Thank you. Choose.
Do you happen to know the number of acres for offsite mitigation plan for?
I do.
I'm gonna give that to
Yes.
Dan because that involves numbers and he's got all that right in front of him.
Fair enough.
Actually, sure some more.
Yeah, so in total, we would be proposing to impact 42.7 acres of new impact to prime ag soil. There are some existing impacts out there, but as far as the offsite mitigation goes, that would be based off the total new impacts, which is 42.7. Working with the Agency of Ag, we've developed the total offsite mitigation acreage based on the prime ag soil value and the respective multiplier, and that is 143.7 acres.
You may have addressed this, in your opening. Oh, sorry.
Fred Booker, they mentioned the orchard, the working orchard. Do you anticipate where you plan on planting the orchard on the property?
Go ahead.
Sure. Do you know the old farm road that goes up? So the thought is because that's gonna be the new main entrance to the property rather than Mansion Drive or Mansion Road.
Okay.
On either side of it, kind of as a tip of the hat. It's not meant to be a commercial orchard, meaning people aren't gonna be coming and picking. The chefs may use it to prepare, meals and cooking classes and stuff like that. But on either side of the road and that lower portion of the property.
So will that replace the soccer field?
Will not replace the soccer field.
You're gonna maintain the soccer field?
The field, will be maintained. We haven't determined the exact use of it yet because we need some of the answers to these questions in order to figure out how the rest of the puzzle fills out.
Okay.
But the orchard will not be on that portion of the property.
Okay, thank you.
That kind of leads into the question I had was, and you may have addressed this in your opening brief, but you're requesting to have the orchard released from primary ag soil, but you're intending to use it for an orchard. Can you talk to that?
So yes, so both the orchard and the upper fields that we looked at earlier today, we're actually going to be touching very little of the land with structures, meaning it's a percentage of it. But because we don't know the final plan yet, because we need this answer, we don't know where the electric lines are going. We're mindful of the state's focus on green energy, and we're looking into geothermal. We don't know where the geothermal lines are going to have to go. And the process of Act 250, we didn't want to have to go and constantly amend our application to say, well, we need another 2 acres over here. We need another. So we just said, this portion's not going to be a farm. And even in the orchard where it is going to be technically a farm, meaning the trees, we may have to run conduits through it. And so we just wanted to remove that designation so that we would have the flexibility to lay the site out within the appropriate areas. But for other reasons, just so you understand, historical, archaeological, wetlands, we can't build in many of those areas anyway. So nothing's going on them. There's not going to be buildings on them.
Right.
It's just we may need to run a pipe or sewer or whatever.
We also anticipate some stormwater management in that area too.
Thank you.
Some gravel wetlands or bioretention areas to treat a portion of the site. So like Michael was saying, utilities, access, all of that. We want the flexibility as we move into design to move those areas around. Yes. And then around that really would be centered the orchard as you drive up into the resort.
Yeah. Excellent. Thank you. Any other questions? Still fine ones?
Can I ask a clarifying question? Just so one of the factors that Chris spoke to was considering other policy considerations. And often, in one of the ways we kind of think about, if something kind of qualifies as a policy is if it's in the municipal plan. But in the write-up that was provided, I guess I'm just wondering if you could provide clarification of the, argument and statement that tourism and historic preservation are policy and kind of what that is rooted in.
And that's more of a general statement that, we're not putting a smelting operation up there or something. It's something that Vermont and Vermont's economy encourages. It's certainly compatible with the broader context of the Bennington area. And, go up the historic Route 7 and all of that. And so that's more generally what it's talked about. Obviously, it's not as specific as the historic preservation policy, which we think is front and center with this.
Helpful clarification, thank you.
Questions? Great. So we have concluded our discussion of Snow Club Highlands analysis for this application. We'll now consider the merits of the application specifically under Criterion 9B, primary agricultural soils. Under Criterion 9B, the commission considers farmland soil map units identified by Natural Resources Conservation Services, NRCS, as prime statewide or local importance. The commission must consider whether map soils have lost their agricultural integrity. Would the applicant like to address anything?
So I'll just, this would be a good time to maybe just bring up the map.
Sure. Yeah, I can go over the areas of impact in the map. So right here, on screen, I have Exhibit 11, the Prime Ag Soil Impact Exhibit. And just for everybody's orientation, north is right on this plan, south is left, up is west, and down is east. And you have Monument Ave down here at the bottom of the
Everybody
sheet.
got that?
So we have a few different hatches.
Maybe for the sake of orientating,
Yeah.
maybe you could point out where the mansion is.
Yep.
And where the direction of the
Sure.
hospital.
Yep. So the hospital is down here at the bottom off the page on the other side of Monument Ave. Up here, you have the mansion in this area up on the western portion of this exhibit, southwestern portion. And then in the central area here is the former Southern Vermont College campus, where you have the fire pond, the dorms, Hunter Hall. This area over here is the athletic center, and then you have the athletic field up here.
Thank you.
Yeah. So there's a few different hatches on this plan. The red hatch indicates existing impacts to prime ag soils on site associated with the redevelopment of Southern Vermont College. And that occurred over the course of several Act 250 permit amendments. Up here, you have the red hatch associated with the development of the Everett Mansion, preceding Act 250 jurisdiction up there. Then you have the yellow hatch down on the west side of the site, and then you have this yellow cross-hatched area on the west side and the east side. And between the yellow solid hatch and the yellow cross-hatched area, that is 64 acres. And those are the previous acres that were set aside for on-site mitigation. And that 64 acres was also referenced under 8B0344-9, the most recent Act 250 finding of fact there. And we worked with the Agency of Ag on confirming and defining that. Proposed impacts include 42.7 acres of new impact, which is the crosshatched area. You have 40.3 acres in this yellow crosshatched area on the east side and west side. That combines the 40.3 acres. And then down here in this pink area is the existing ball field that would propose to be redeveloped, and that is 2.4 acres. So in total, there would be 42.7 acres between the yellow crosshatched area and the pink crosshatched area. Additionally, we would be seeking to impact the 40.3 acres of previous. Sorry, I got that mixed up. We would be impacting this red area in here of the former Southern Vermont College campus too, but those were existing impacts, so we're not seeking off-site mitigation for those areas as they were previously permitted. And that's it. I'd be happy to answer any questions the commission has regarding impacts.
In the application, Exhibit 11 identifies 3.6 acres that have lost agricultural integrity due to steep slopes, and 3.8 that have lost the integrity due to wetlands. Can you just speak to that?
Sure. So this green hatched area up here is the area of soils mapped 1 through 7. But the slopes are steeper than 15%. So under prime ag soil regulations, they wouldn't be considered prime ag soils because the slopes are steeper than 15%. And then down here, you have the blue area around the ball field. That is within mapped wetlands or wetland buffers. And we've confirmed those wetlands with the state, with DEC last year. So those are not considered prime ag soils either.
Okay, thank you. Devin, Don, any questions?
I think so.
The only other question I have is do you have a number of the proposed on-site mitigation areas that are going to remain? How many acres contain wetland, class 2 wetlands or wetland buffer area? Do you have that number?
I do not have that number on me. Yeah, those areas were set aside and wetlands change over time. So I think we redelineated those and some areas grew, some shrank, but I don't have that number, but I could get that number to you.
Yeah, we may add that to the recess.
Yep.
So this may be a crazy question that you can't answer yet, but in the description of the orchard, it talked about horseback riding. Do you anticipate where these horses will be housed? Or
I didn't see that description.
it was in the, kind of like the description of what the hotel would allow, would be provided.
Said a question.
As of right now, we're not planning on having
Okay.
horses on the property. So.
Okay, thanks.
Says a question.
I thought it
If
was.
we want to go horseback riding, but there are plenty of facilities around that we could contract with to provide horseback riding facilities elsewhere in the area. I don't think we would provide it on the.
We're not planning to have it on site.
Okay.
Yeah.
Yeah.
Any other questions before we go to online? You would unmute Ari. Any questions or comments? Ari? Before we move on to sub-criterion.
Thank you. Yeah, Ray Rockland Miller with the Agency of Agriculture, Food and Markets, Vermont. I think what was just presented as far as what Dan Heil presented with the kind of the numbers as far as the figures of the proposed new primary agricultural soil impacts and the kind of the remaining on-site mitigation acreage, that was all consistent with our 9B review letter. So, which is an exhibit on the Act 250 database. So yeah, I don't have anything to add to that aspect, but if there are questions, happy to address them.
Excellent. Okay, so we can move on to sub-criterion 1. This criterion requires that development not significantly interfere or jeopardize the continuation of agricultural or forestry on adjoining land or reduce their agricultural or forestry potential. Anything you'd like to give a brief overview on there before questions?
No. Well, I'll just say I can share this exhibit again. So when working with the Agency of Ag, defining these impact areas, not all of these areas that we're seeking for off-site mitigation are necessarily going to be impacted. However, because of the anticipated development, some areas may have been fragmented or removed. So we incorporated those into our into the off-site mitigation areas. So this area in the northwest corner of the parcel here, we're not anticipating to impact this sliver back here. However, we would be impacting this area down here. So we accounted for the removal of that area as part of our exhibit.
Okay.
Because that would have been fragmented and resulting in widths less than 100 feet.
Yeah, so the use of it, even though you're not intending to use it, the use of it for primary ag soils is
Sure.
not relevant at that point.
Yep. And then there's some areas down here as well as you get closer to the existing ball field that we're removing. That may be part of the resort. It may not be, but the widths are less than 100 feet. So we remove those areas as well. So we tried to consider areas that would have been fragmented and incorporated those into the request to seek off-site mitigation.
Excellent, thank you. Any questions under sub-criterion 1, commissioners first?
I do wonder, the idea is to delineate the prime ags that you need to use, and I understand that you're gonna need to use it to put in power lines or water lines, whatever. Once that is completed, you have said that you would like to maintain a portion of it, at least for the orchard. And then as we were looking at it, the space below where the cottages would go as not, it's not what you're interested in building in. And I'm wondering if you guys would be amenable to that being a requirement of this permit.
You mean, can I
Sure.
go to the map? Just 'cause
Sure.
I'm not sure what you're talking about.
Yeah. We're talking about like the orchard area and then below the cottages.
Talking about over here?
Yep, well, you're up where the orchard would go.
So the road's coming in
Yep,
along here.
yep. And the
The
orchard.
orchard will go on either side.
Mm-hmm,
This is a retention basin.
yep,
We may have some, Dan would have to answer it, where we're gonna have to steer
Yep.
runoff for, this may expand or be, and a lot of it is wetlands
mm-hmm.
over here. So is this the area you're talking about?
I'm really talking about the orchard that we're talking about using as a tag, so to speak. And then above, where below where the cottages are gonna go is that other field. Cottages up by.
This field, upper field,
The upper field where the cottages,
over here.
yeah, along that tree line, we were looking at it earlier today, above that section.
Oh,
Yep,
up here.
Yeah, and then you had below there, we have that field, that you said you weren't interested in.
So this is the field that I think
have to keep that
you were.
I'm gonna step off here, show you what I mean. That's all right, this is good. So we're,
There's two fields. There's the ball field, right here.
I'm talking about this field here.
These fields are left. Why, we're not putting any structures there.
Right, you may need to use it to get.
We may need to,
Conduit
the
infrastructure.
geothermal, the so on and so forth. We can't use this for any structures for two reasons. One, it's against the town charter.
Okay.
And two, it's against the National Registry of Historic Places view line. We've already had them review it. So nothing physical, meaning above ground, is gonna go there. But we didn't want to have to modify our application as we're going through it. Once we lay out the buildings and the engineers go.
And that's, you answered my question there, because that can be added to the. Will not be developed because it can't be developed.
It can't be the city.
And,
Dan has already told us.
all right,
There may be some drive access.
yeah, and I understand that part.
But there is, yeah, you're gonna have to access this field and fire safety.
Yep,
As well.
Yep, okay. Answer my question, thank you.
Anything online?
Raise your hand if you have anything online, please. Okay.
Move on to sub-criterion 3. In sub-criterion 3, it requires development has been planned to minimize the reduction of agricultural potential of the primary agricultural soils through innovative land use design resulting in compact development patterns, so that the remaining primary agricultural soils on the project tract are capable of supporting or contributing to economic or commercially agricultural operations. I think he addressed a few of those, just in the last section as far as why you were removing a few. So thank you for doing that. Is there any overview addition that you'd like to touch on regarding sub-criterion 3 before we move to questions?
I'm just gonna pull up exhibit 4 real quick. We've been looking at the Prime Ag soils exhibit, but this is the conceptual master plan, which gives a little more context to the development areas and those areas that we would be impacting for Prime Ag soils. So this would be the new drive that follows the existing farm access road for a portion, and then it would deviate up here. And in the background, you can see these little green circles. That is conceptually the orchard. I think we'll need to play around with those areas to stay out of archaeologically sensitive areas or devote some of those areas to stormwater management. But the proposal as a whole has been designed to cluster the development to the existing college campus area down here where Hunter Hall is, the dorms. You know, this would be the resort core, we're calling it. So you'd have a spa, you'd have a hotel with keys there, an amenity area. The field house would be developed. So clustering development to the, you know, the existing developed areas. And then we would have, you know, portions of the site where there would be the villas, and we're trying to, these are the villas along that western tree line that we're proposing to push or cluster against that western tree line to leave the field open. We may have utilities or access going up there, but the intent would be to cluster those villas against that western tree line to preserve views from the resort as well as, you know, from the valley below looking up. So the design, while we are seeking to remove, you know, the on-site field areas to allow for flexibility and design for utilities and access and potential geothermal, we are proposing to cluster the development to, existing areas in the perimeter of the fields.
Helpful.
John, just to maybe help this discussion as well, something that's not in your overview, but I could just provide the definition of compact development patterns that we're working with in this context. So this means the use of innovative land use to design specifically intended to minimize or eliminate the fragmentation of primary agricultural soils on the project tract, thus preserving a percentage of the prime ag on a project tract or tract capable of supporting or contributing to an economic or commercial agricultural operation. So it is compact development, but also in the context of not fragmenting the primary agricultural soils. So I just wanted to bring that in the discussion.
Yep, understood. And I think I touched upon it before. We've been removing, certain areas that won't necessarily be impacted, but would have been fragmented. So we're seeking for those areas to be removed.
So it looks like those villas that are at the top of the drawing there are kind of going along the carriage path that goes to the mansion.
Just below the tree line. Like
You're gonna build
tucked up against
below the tree line?
Carriage path will remain.
Okay.
And the trails will
Trails will
remain.
remain.
And the fats trails going up and the access to them will all remain open to the public.
Okay.
Any other questions? You can move to appropriate circumstances, factor 1A. The tract of land containing primary agricultural soils is of limited value in terms of contributing to an economic or commercially agricultural operation, and devoting the land to agricultural use would be impractical based on the size of tract of land or its location in relationship to other agricultural or non-agricultural uses. I'd like the applicant just address factor 1A and your position on that, and then open things up for questions.
Yeah, Chris, do you mind handling that one?
So I will, just for a little bit of context, so we've moved on to the appropriate circumstances analysis for members of the public as well. So this is what the commission needs to consider in order to consider the applicant to allow for off-site mitigation, which is what they're looking for. So that's the analysis we're working on now.
Chris is up.
Yes, so under the criterion, there has to be a consideration of the factors 1A through 1C, and then a positive finding with respect to 2. And I think that as we laid out in the memo, those factors all weigh in favor of a finding of appropriate circumstances. Starting with 1B, as I mentioned earlier, the land has been rezoned, or would you rather I go 1A and then we kind of punch through it one at a time?
Yeah, we're gonna walk through each one, so we can do that all together at this point, because I addressed it.
The volume on. Or unmuted yourself.
Somebody unmuted. They're remuted.
I shouldn't.
No,
You're all
right.
set.
You're good.
Somebody in
Sorry.
the crowd, Chris.
Okay.
That, you're gonna address all factors, 1A, B, C. You can walk down through each one individually, and we can just pause between each one, just so we can have any discussion around each factor.
Sure, and I'll just do it in order. 1A relates to the viability of the property as an active agricultural property. And as you know, and as we've mentioned, this property hasn't been used as an agricultural property for some time. And the community has specifically rezoned the area to allow for this kind of use. So in sort of weighing the relative benefits of requiring on-site mitigation or finding a high value property somewhere else where mitigation fees can be used to preserve viable agricultural soils, we think under the circumstances, this requires a finding of an appropriate circumstance with respect to the viability and desirability of having this be a viable agricultural operation in the future. And I'll stop there with 1A.
Excellent, thank you. Yes, I would like to ask the Agency of Agricultural to just weigh in on that and your opinion on the viability of the property to contribute to an economic or commercial agricultural operation, and you're in the process of being unmuted. I believe you're good to go.
Thank you. Yes, Ari Rockland-Miller with the Vermont Agency of Agriculture, Food and Markets. Yeah, so the agency's practice as far as the specific appropriate circumstances analysis is typically to defer to the district commission's findings regarding appropriate circumstances. What I can say is that as far as the agency's review letter, the acreage of mitigation that is calculated, which I believe is a total of 143.7 acres proposed as an offsite mitigation fee to Vermont Housing and Conservation Board toward farmland conservation easements. That number includes both the proposed release of the portion of previously set aside on-site mitigation soils as the applicant explained, it will be released for this project subject to the commission's findings. And then that also includes the new proposed development acreage. So without really weighing in directly on appropriate circumstances, I can state that the offset mitigation fee as proposed, as I understand it, is addressing the portion of the previously set aside on-site mitigation, which the applicant is proposing to release. And there's a kind of a 1-to-1 ratio specific to that proposed release of those previously set aside on-site mitigation soils, which I think the applicant explained kind of the rationale for why they proposed to release those. And that number also includes the new proposed impacts associated with this specific application. And for those new impacts, the kind of the standard multipliers based on agricultural value group are applied. So yeah, I can kind of say that the applicant's proposal includes both the proposed release of the previous onset mitigation land as well as the new scope of the development.
Could I add something?
Sure. Thank you.
So this is Exhibit 10, the existing conditions plan. And while, there's 64 acres of existing on-site mitigation that was set aside over time, under the new definition of prime ag soils, we don't consider soils greater than 15% prime ag. And this exhibit kind of has a slope analysis map that shows area where those slopes exceed 15%. This red hatched area here. So looking at the east side of the site, where we would have the new drive following a portion of the farm access road, that the orchard area, utilities, that area we're looking to have released, a good chunk of those soils over there are actually greater than 15% and don't meet that current definition of prime ag. Going up to the field, there are some areas in the field that are less than 15% that aren't hatched, but there are also other areas that are steeper than 15% too. So I recognize that the areas exist and they're set aside for prime ag, but under the current definition, with those slopes being greater than 15% not considered prime ag, today, those soils would not meet that definition in some of those areas.
Thank you. Any other questions on A?
But there are two spots there.
Please speak up.
there are two existing food sources there right now.
Can you speak to what those are? Sorry.
Well, there's an old apple orchard. I've used it for years to gather apples for my family.
Yeah.
There's another one that's extremely rich, but I'm not willing to say what it is. But it's obviously from the original farm, and that, I would say these soils are incredible. So I think that has to be taken into account. That could be a wonderful garden area.
Thank you.
I can say that I have a suspicion as to what the other food source is, being someone with a mycology background, but I'm not going to comment on that here. Maybe I'm off the mark there. Well, but yeah, I mean, I will say that I think that the applicant's proposal, like I said, proposes to address the proposed release of the onset mitigation soils. They're proposing to use an offset mitigation fee, with the multipliers to address that. So I think that they make those points are well taken. I would only hesitate to say that I wouldn't discount that the soils had any agricultural value where they've been previously set aside for onset mitigation. This property portions were previously an orchard, which did, and part of the definition of primary agricultural soils today, just for general context for other reviews, is that soils that are kind of in recent agricultural use can meet the definition as well due to kind of their proven ability to grow crops. I recognize here, though, that the applicant has explained kind of a rationale for why they proposed to release those, and they're proposing to mitigate it through a fee. But I wouldn't want to discount that the soils have had potential to grow orchard crops, and many of these soils are mapped as being statewide or prime farmland. But I think that like I said, the mitigation proposal does propose to address both the release and the new impacts in full.
Excellent. Thank you. Okay, I think we could probably move on to factor 1B, which is the project tract is surrounded by or adjacent to other high density developments with supporting infrastructure, and as a result, a good land use design. The project will contribute to existing compact development patterns in the area. Chris, if you want to move into B.
Sure, and briefly, I think there are three elements to this. One is, as has been mentioned, on the other side of Monument Ave from this property, you have the hospital complex, which is obviously a substantial development. You have the existing property, which has been a college campus for going back 50 years. And then, as I mentioned earlier, you have the concerted effort by the community in looking at land uses in the area and the goals of the community to rezone this to allow for this type of resort development. So we think those three factors all weigh in favor of a finding of appropriate circumstances under factor 1B. And again, you don't have to, it's not you have to satisfy A, B, and C. It's a matter of considering all of those and see if there's sufficient findings. And then you move on to 2 after that.
Thank you. Any questions under B?
The high density, where is the adjoining high density?
It would be across Monument Ave, the hospital complex.
That would be, but it's separated from the track by the hospital. So that where the high density is track beyond the hospital. I'm not sure that's adjoining.
So properties across the street are adjoining, so if they're just separated by one roadway.
It's separated by the hospital and that development.
Yeah, it sounds like, which you can ask some more follow-up. What I'm hearing is it's the applicant's position that the hospital is high density development and maybe, and so if you can expand on that.
High density, a lot of patients.
So that's, I don't know, Chris, could you clarify, is that the position?
Yes, I mean, in speaking of development is, you've got a big parking lot, you got several big buildings and you've got people moving in and out. So it's not, virgin forest, it's a hospital complex. And with all of the activity, that goes with that. And so that's really the context that you find this property in, which is literally across the street from the hospital.
That area is designated as a growth center as well. And so there's potential in the future of who knows what's going to happen in the future, but there could potentially be additional development in that area.
Potential means it hasn't happened yet.
That does need to happen. But
Can speak for the town and as a planning director that we would definitely consider the hospital as a high density area. It's as I was reminded, they have 1,200 employees and how many patients go there each day. That probably is a quintessential high density area. How that impacts your decision, I don't know, but definitely high density.
Thank you. Anything online? Questions?
I'd like to give you guys an opportunity to speak to the good land use design that you are putting forward. This project.
So I can provide just a little bit more context there. Yeah, so this factor also states, as a result of good land use design, the project will contribute to the existing compact development pattern. So we've talked about compact development patterns earlier in the analysis, but this factor also considers that.
so I'll pull up this screen again. Sure.
Sure. I think all along the intention, and you can see it in this draft of the site plan, has been to primarily stick to areas that have been already developed. And out of the 140 acres in total of the developable acres, I think the total property is 371, but the upper portion is part of the Vermont Land Trust easement and the trail system. We're actually taking up a very small footprint of new developable area. As we had said previously throughout, we've tried to consolidate it around the core and around that view line along the tree line, and leave the majority of the rest of the space open, partially because it's efficient in terms of development, but it also maintains the integrity and tranquility of the site itself, in that the goal of it is to create a peaceful retreat that people can go to that enjoys nature and is, open to the elements. And so we wanted to leave a lot of the space open, and it will remain open as a percentage of it.
Thank you.
Okay. Doesn't look like there's any other questions around B. As Chris said, you stated earlier, the applicant doesn't need to present on all three factors. Really simply, you need to meet one of them in your application. You didn't present an argument under C, but I'd like to give you an opportunity if you wish to address C.
Sure, and I think that would be because the point that would be made under 1C just builds on points that were made with respect to A and B. That factor looks at the uses, including commercial, industrial uses and residential uses supported by municipal infrastructure that are in the area. And again, that ties into the 1A and 1B. And we think, given both the existing conditions, the existing infrastructure, and the planning that the community has done around this portion of town, that 1C as well. But that all ties into what we had argued with respect to 1A and 1B.
Great, thank you.
Just going back to my point before too, up until 2016, under these previous amendments, the site was served by an on-site water supply. 2016, Bennington constructed that municipal water system. So in regards to 1C supported by municipal infrastructure, there is municipal water and sewer up there for the project to tie into as well.
I don't believe there's anything else to address in factor 1C, but it's good. So the next factor that the commission considers and ultimately the commission determines that payment of an off-site mitigation fee or some combination of on-site and off-site mitigation will best further the goals of preserving primary agricultural soils for present or future agricultural use, with special emphasis on protecting prime ag soils, thus serving to strengthen the long-term economic viability of Vermont's agricultural resources. In this one, if there's anything that you guys would like to address from the applicant standpoint, I will note that our intention today is not to reach a conclusion of factor 2 during this hearing. We just need to gather enough information through the hearing to determine our conclusion. So if there's anything that applicant would like to touch on here, would be great. I don't believe at this point I have any questions to help me form that, but Devin, Don, if you do. So. Anything additional you'd like to share? You certainly don't need to.
Yeah, I just like to point out that, we are seeking the off-site mitigation, but also preserving a portion of that on-site area, retaining that 23.7 acres of on-site. So it's a combination. We are seeking that off-site mitigation for proposed new impacts, but also preserving portions of the on-site mitigation area.
Thank you.
And you said that was 23.7.
23.7 acres of existing on-site mitigation to remain.
Thank you.
That's that yellow salt.
And that really goes to the underlying policy of you not only want to preserve primary agricultural soil, but you want to preserve primary agricultural soil that has real value and viability to be used for agricultural purposes. And that's why the legislature had adopted this, because in many respects, if you're talking about prime ag soil that's located near or around development, it may very well be better to really work to conserve and preserve viable agricultural soils outside those village areas or town centers. And that's why we think in this circumstance, it really, let's use the mitigation fee to invest in more viable, more valuable soils located in areas that are going to be more amenable for use as an active agricultural operation.
Okay. Well, thank you, everyone. Thank you for your participation. The commission will now consider all the evidence and testimony presented today. Next, the commission will issue a hearing recess order, which keeps the record open for a time. Typically, a hearing recess order asks the applicant and sometimes other parties to submit supplemental information in response to questions that were raised today, and allows parties an opportunity to respond to those supplemental findings. Once the process is complete, the commission will consider the record to be final. Once we have all the supplemental information that we need, we'll deliberate on the issues and issue our decision as quickly as possible. If there's no further comments at this point, we'll move to close the hearing and put it recess the hearing. We have one more.
So my name is Kevin Bisacchio. I'm a resident here in town, been here since the mid-80s, raised a family, been in commercial banking. Just about every committee I've been on starts with B, but BCIC, Bennington County Industrial Corporation, I spent about 25 years. And we've nurtured a lot of small businesses. And I had a chance to meet with Michael Cohen, some representatives from the hospital. And I really think we urgently need this project, urgently. And I just thank the commission for coming down and taking the tour. And I just wanted to lend that support as a resident who's been here a few years. Thank you.
Thank you, Kevin.
Hi, this is really just a question. Leslie Addison, resident of North Bennington. So you'd mentioned earlier that there would be similar hearings that address other criteria of Act 250 and will be publicly announced, particularly regarding public access to the trail system, which I'm an avid user and supporter of. So I guess my question is, will it be announced the same way this was, and people have an opportunity to comment on all those other criteria?
Yeah, so the applicant requested to just focus on this area before moving forward to next steps in the permit process, which will be all the rest of the criterion and the things that you're asking about. But I will give the applicant an opportunity, if they wish, to share their perspective on your question.
We have worked with the Bennington Area Trail System, the Vermont Trail Trust, to ensure that the access to the trail system will remain open. We're going to be building 2 parking lots. One by the entrance point, one down by the road, and they will 100% remain open to the public.
And we'll have opportunity to comment at the hearings when those portions of the criteria come up as well.
I'm assuming I've
Yeah,
never been through this process.
Okay.
Yeah.
Thank you.
First for me, but yeah, if they say yes, then yes.
I'll chime in, yes, because this is expected to be the first of the 2 applications. Everyone who provided their email addresses today will be kind of added to the interested persons on this application. So when the applicant files their secondary application, and then that is at the point of public notice, that can be forwarded to people who provide their email address today directly, or a mailing address. We do snail mail as well. So that's the benefit of attendance today. We now have your contact information. And also I'm Quidman, I'm the district coordinator on this project. If you have questions about engaging in the process and want to have more discussion about that, you can reach me via email and touch base with you after recess here. Yep.
Other comments? Questions? Hearing none, the hearing is now in recess. Thank you.
Thank you
Thank
very
you.
much.
Thank you.
Thanks, everyone.
Yeah.
Really?
Bob Taggart with the museum.
Yes, no, I remember you. You gave me all that beautiful photographic.
Yeah.
Historical
We're here
information.
to help you, you know. This is gonna be like, historic preservation.
So I only